Good morning, good evening, good afternoon. I'm just going to start going. I'm sure most people will be watching on a replay. Just to kind of get the ball rolling while people are coming in, Delete Laws posted this on his community page. I don't subscribe to him, but it showed up on my recommended feed. Maybe somebody had responded to it. I don't know. But he, as a constitutional law scholar, you would think that he would better understand the interplay between a state's qualified immunity and federal qualified immunity. He says if you're running around saying abolish qualified immunity, you did not learn that from a constitutional law scholar. Well, I mean, the bar to entry to be a constitutional law scholar is so low that literally anyone can claim to be a constitutional law scholar. As we can tell, Chile, without any training or any education, has proclaimed himself a constitutional law scholar. So how does he know who they learned this from? It could have been another, in air quotes, constitutional law scholar. He says it is ignorant to keep repeating misinformation. I'll delete comments that say that. It's Terry v. Ohio. That's our problem now and has been for decades. Well, so the weird thing about Terry v. Ohio is that passed in the 60s. So what is he suggesting? That before the 60s that there was no police abuse, that police abuse started in the 60s with Terry v. Ohio? I hate to break this to Delete Laws, but prior to Terry v. Ohio, cops were doing the exact same thing. The Supreme Court just hadn't addressed it and said, yeah, what you're doing is fine. They were literally doing that, which is why Terry v. Ohio became a case. It's because they were doing that and someone had the bright idea to challenge it in federal court as a violation of the 14th Amendment or the 4th Amendment through the 14th Amendment. And ergo, you end up with Terry v. Ohio. They were doing it, which is why it became so. That's just stupid. That's our problem now and has been for decades. QI has been abolished in New York City, New Mexico, Connecticut, and Colorado. Well, yes, Julie, you can also be a constitutional law scholar. Here's the fun thing about New York City. New York City can only abolish qualified immunity for New York City policies, ordinances, laws, whatever. New York City is a sub-unit of New York State. So they can't abolish qualified immunity in New York State, which is why it's New York City. New Mexico, Connecticut, and Colorado, what are those? Those are states. They cannot affect qualified immunity in the federal government. So a federal court applying can and still will apply qualified immunity standards, to a federal cause of action in federal court. Now, a state cause of action in federal court, they probably won't because, well, a state would not allow that particular defense. However, the state can't take away from the federal government the power to create its own laws. And the federal government, through the federal courts, have said that state actors that are sued in federal court under 42 USC 1983, a bunch of apparently piss stained fish tanks. If a state actor is sued under 42 USC 1983, they have the right to qualified immunity. And I would argue that they would have the right to qualified immunity if you sued them and say, like, for example, I know you can sue under 42 USC 1983 in state court because you could do it in California. If you could do it in California, you could do it in other states. And they would apply the federal qualified immunity standard to it. So he goes on to say, how's the Loveland PD in Colorado? QI has been abolished from Mexico for 2 years. How's it going? Awful. QI has zero on the street effect to you. So there you go. Terry v. Ohio is why cops can walk up to you, say they're suspicious of you, and detain you, torture cuff you. Yes, because of Terry v. Ohio, they can torture you. So anyway, that's nonsense. The next thing that I think we'll talk about is probably going to be Springer. Yeah. Let's switch to Springer. I closed it for some reason and I didn't mean to. SPR. So this is the current situation on Springer. He filed an opposed motion for leave to file surreply, right? So unless the court grants that motion to file surreply, pleading's done. Pleading's done on that, or I'm sorry, briefing is done on that particular motion. It's not a pleading technically, but I just loosely call it all pleading. So unless the court grants Springer leave to file a surreply, he can't, right? So what does this idiot do? Oh my God, this is just absolutely amazing. Notice by James Springer regarding supplemental authority and supplemental information. You can't make this shit up. How do you notify the court of supplemental authority and supplemental information? Well, you do that in your motion, in your opposition, in your reply, in your surreply. That's where you do it. You don't do it in a notice of supplemental authority. The proper notice of supplemental authority would be if a court with binding authority over the lower court. So if in this particular case it'd be the 10th Circuit. If the 10th Circuit came out with a case where the facts were on point, you might want to file something like this, a notice of supplemental authority. Or if the Supreme Court came out with a ruling where it somehow did something that it just unavoidably affected your case, then you might file something like this. But what does he do? This is his notice of supplemental authority. Comes now, plaintiff, by and through undersigned counsel, and in furtherance of their duty of candor. We had a duty of candor to the court. You know, we didn't want to do this, court, but we had a duty of candor to the court to inform the court of this. We had to inform the court of this. To supply with supplemental authority recently decided en banc by the 5th fucking Circuit that relations to the defendant's pending motion to dismiss. So wrong fucking circuit. And now let's look. This dumb motherfucker, he printed out the Westlaw version of the case. You just print out, like, go ahead, Your Honor, go ahead and read 38 pages. Go ahead and just fucking guess what part of this applies, if any. I know. The court said that qualified immunity applied. Now, I'm baffled. I'm fucking baffled why, number one, he thinks it's a good idea. Why does he think News Now Fort Worth, this is Springer versus 7th Judicial District Court? But why does Dunn think this is a fucking good idea? See, Springer versus 7th Judicial District Court. Why does Dunn think this is a good idea? What is he fucking hoping to accomplish with it? And then this is his notice of supplemental information. Again, like, you don't have leave to file a surreply yet. You're just doing it. He's just fucking doing it. And what is it? It's body camera footage from October 31st. There's 6 different body camera films that apparently deal with when the state police, New Mexico State Police, went to a courthouse somewhere, and you can see Springer in some of the shots. What material does that do to affect anything on the motion to dismiss? I am absolutely baffled. Absolutely baffled. This is the worst lawyering I've ever seen. I'm baffled. Like, I guess as like a last ditch effort to get something like this in front of the judge, sure. But then, like, at least put something in here that says, these body cam footages are relevant because X, Y, and Z. Like, don't just say here's an hour or two worth of body cam footage. Say, like, this one at this point shows this. This one at this point shows this. This one at this point shows this. Unfucking believable. And then finally, we're not going to go over the decision. It should be enough for you to know that I was right. Neener. I don't think Springer got $500,000. Number one. I thought he was dismissed. I don't remember him actually being one of the ones that made it through. If he did, it's been a long time since I've gone over it, but I would press X to doubt that Springer got 500,000. He got some money, but I doubt he got 500,000. And I could be wrong. So anyway, on Turtleboy, this is Turtleboy. I was right. The judge said, no, we're not going to. He was, yeah. It wasn't. I don't think it was 500,000. So Bradel was not sanctioned by this court. This court said that something like that should go to the disciplinary committee, and the court also declined to appoint a special master. Like, it was just so dumb. I am told that Mello has a. Why don't you ask him? Why don't you ask him, Tim? That seems more like his information to give out than for me. I'm told that Mello is struggling with some sort of an illness. Now, I don't buy that excuse. I'm not saying that he's not sick. I don't buy the excuse, because you have a duty as a attorney to zealously and effectively represent your client. And if you are incapable of doing that, you have a duty to not represent that client. You have a duty to find someone else who could take over and associate them in, so that they can then zealously represent their client. You have a duty. You can't just say, I'm sick. So it's important. It's important to know that his being a fucking retard and incompetent is not something that you can excuse away. That's my point. The next thing is this particular motion right here. This is Bradel's emergency motion for relief from the order revoking bail. And I'm not going to go through it. It doesn't really say anything or make anything that I would consider to be an effective argument. And in fact, it says some things which I think would actually jade the court against ruling in your favor, because he characterizes that the complaints against Turtleboy are for de minimis allegations. Now, for those of you who aren't aware, de minimis means like minimal, like inconsequential. What he's saying is that 16 or so felonies are de minimis. They're inconsequential. Who cares that he has 16 fucking felonies against him? That jumped out at me with craziness. So as far as predictions go on this, I don't really know, because there's a real weird thing that I have figured out. Let's see if I have it. Yes, I do. Let's look at this. So, unless I'm wrong, and I may well be wrong, the Turtleboy was originally given bail from the district court for the original charges. Then Mello got his true bill for, I'm going to say, about 16 charges from the grand jury, and then moved it into Superior Court. The difference between the two fundamentally is that in the district court, you're limited to 2 years of time that you could serve. And in Superior Court, there's no limit to the amount of time you could serve. And in order to get into Superior Court, it's got to go through a grand jury. So, oh, Jesus fucking Christ. Like, this isn't politics fight for rights. No, you just use common sense. De minimis is a matter of common sense. Like if you're a cashier at McDonald's and your till is off by 3 cents at the end of the night, that's de minimis. 3 cents, who cares? If your till is off by $200, that's not de minimis, right? Fight for rights. You're in the wrong place. You're in the wrong place to be conducting activism. We're talking about the law. We're not even talking about Carney right now. So fucking cool your jets and relax. Just fucking cool it and relax. I'm not even a lawyer. Okay. You're right. Whatever. I've just been right all this time. I'm not even a lawyer. Why are you even here then? How about this? How about let me help you leave? I'm going to enable you to make better decisions and not listen to non-lawyers. So here's the weird thing. So when it went to the Superior Court with new charges, remember there were like I think 9 originally. Through the grand jury, it came back with like 16, and so now there's new charges, and they're in front of the Superior Court judge. So Mello asked for restrictions on Carney, but own recognizance, because Mello didn't know what the fuck he was doing, and then the court ended up giving him just own recognizance, right? So now a Superior Court judge, a Superior Court to the district court, meaning a higher court than the district court, made a bail order on Christmas or thereabouts. Carney caught a couple more charges. Now he goes back. So now there's 2 more charges. So, and these are in district court because Mello hasn't gotten true bills yet from him, right? So Mello goes in front of the court. Now there's already bail set on these 16 charges. So he goes in front of the district court, as he has to, Normally at this point, from my understanding, and I don't practice law in Massachusetts, obviously. I'm just a first-year family law attorney out of California. And as the previous gentleman stated, I'm apparently not even a lawyer. But I definitely don't practice law in Massachusetts. My basic understanding is that the district court judge would have been setting bail on just I think it was 2 new charges. So instead of just proceeding to argue on bail about the bail on the 2 new charges, Mello, in his infinite wisdom, decides to file a motion in the district court to revoke the bail that was set by the superior court in a different case. He says that the defendant was arraigned in Norfolk Superior Court on this charge for 8 counts of witness intimidation, 5 counts of picketing a juror, and 3 counts of conspiracy. So in a different case, in a different court, he was given bail. And Mello asked the court to revoke the bail. Now, I haven't seen that court hearing, so I don't know exactly what is or isn't on it. So the court just allowed it and signed off on it that Carney is to be held without bail for a period not to exceed 90 days. But did the court have the authority did the district court, which is something I don't know and I am somewhat concerned about, have the authority to revoke the bail set by a higher court? That's what we'll see. The arguments that are made by Bradel in his emergency petition for relief, they aren't great. And what it appears is going to happen is that it's going to go in front of a single justice of the Supreme Court. Now, I don't know if this is a real Supreme Court. This is Supreme Judicial Court for Suffolk County. Like whatever the fuck that is, right? Is that a Supreme Court or is that like the Court of Appeals for Suffolk County? One of the two. I don't know. But he's asking for a de novo review. De novo means it would be all new again, as if it were like done again, all from the get, right? So it's going to be interesting. I don't think if it is a de novo hearing, if he is granted a de novo hearing, I question whether or not he will prevail, because despite the statement by Bradel that witness intimidation is no, this is the motion. It's filed in Dedham District Court. It's the motion to revoke bail, and it's signed by a district judge. So I don't. It doesn't appear to be. I could be wrong, Paul. I didn't watch the hearing, but my understanding is that this is in front of a district court, not a superior court. But back to this. The issues that Carney is facing, despite Carney's, this is all just First Amendment. Those issues are serious issues. Witness intimidation is a serious issue. picketing jurors or picketing witnesses, serious. This stabs at the heart of our justice system. You know, the First Amendment has limits. We know that. And one of those limits is where your First Amendment rights counter justice. So, for example, in a courtroom, you have very few First Amendment rights because the court's primary goal is to achieve justice for the participants in that particular case, not to provide you with a soapbox. So there's serious charges. And the fact that Carney is alleged to have continued to do witness intimidation while he was out on release owed and recognizance would, to me, signal to the court that he should not be out on bail. You have a right to bail. The right to bail extends to states. Your constitutional right to bail extends to states, but that right to bail is not unlimited. And if he's just going to go out there and intimidate more witnesses, then that's going to be an issue. Is the claiming medical issues, but then trying to claim he doesn't have to disclose those medical records under privacy? I don't know what medical, I didn't see medical issues. I don't know where, I didn't see anything about medical issues. Uh-huh. I don't know what medical issues you're talking about, Kefalia. But that's it. That's it for today. Thanks for watching. Have a great day.